Right, we'll begin. Welcome to the 2024 ARIAS UK half-day conference. And for those members who I hope are going to stay, the AGM, although that will be brief. Now, this is the first half-day conference for a while because we've suffered because of COVID. It's taken time to get back, but we're now in a renaissance, as it were, starting with the earlier talks in this year and continuing with this half-day conference, which is not going to be a very detailed trot through the law reports. Instead, our speakers are going to give some practical tips and advice about how best to conduct an arbitration and how to avoid any challenges. Before we progress, though, I've been asked to give you some very important information. The fire exits are just past the 9th floor reception entrance. For those in the room, the loser in the corridor just outside the conference room, there is a fire alarm test at 10 a.m. where we will break, and I'm sorry about that, Joe, we will break for a moment. And if one is keen to go outside to enjoy the London fresh air, one needs that QR code to get back in the building on the slip. That was the housekeeping. So let's start straight away. We've got two talks over the conference today. First by Joe Higgs KC from 7KBW about Halliburton, a case which has caused angst and worry to many and joy to those who wish to challenge. And we want to look at what that case says and also its implications to how to deal with it, not least because now the dust has settled, one is beginning to see the problems with its application. And then later this morning, Paul Stanley KC is going to come and talk to us about the H case that he did, which was a complete car crash of an arbitration. And he's going to tell you how to avoid appearing in the commercial court being challenged. So without any further ado, I'm delighted to introduce Joe Higgs from 7KBW, who knows all about Halliburton, and she's going to tell us how not to make mistakes on disclosure. So if I may, I will hand over without further ado to Joe.
Thank you very much, David, and thank you all for having me here this morning. I start by saying that although I've acted in very many arbitrations as counsel, my career as an arbitrator is in its infancy. So whilst I have regularly been involved in recommending arbitrators and considering their suitability in light of disclosures they make, I've had very limited experience myself of having to grapple with the question of what disclosures I should make, although coincidentally enough, this talk came at the same time as a particularly difficult disclosure I had to decide, so it's been quite helpful for me. I do have the advantage of being in chambers with and being friends or colleagues with many very experienced and distinguished arbitrators. And I've been able to discuss with them some of the issues that arise in practice. And I will be able to share their views and insights on a no-names basis, which will hopefully give you a bit of guidance as to what people sort of are doing generally. What I'm intending to do in this talk is start by giving an overview of what the Supreme Court decided in Halliburton, then move on to what that means now for giving disclosure in practice in different arbitral contexts, and then finish up with some practical tips and suggestions about what to do when giving disclosure and how to avoid the potential pitfalls that arise. So turning to Halliburton, I'm sure most, if not all of you, are very familiar with it, but the judgment does bear rereading, and it's worth a recap of the key points that were decided. The claimant insured was Halliburton, and the defendant insurer was Chubb, and the incident which gave rise to the arbitration was the Deepwater Horizon oil spill. It was a Bermuda form arbitration, so it was an ad hoc arbitration rather than one subject to the rules of a particular arbitral institution. In the normal way, in accordance with the standard clause in a Bermuda form arbitration, the parties each appointed their own arbitrator, but the party-appointed arbitrators couldn't agree on a chairman, so the commercial court in England was asked to appoint a chairman. One of Chubb's nominations had previously been involved in a number of arbitrations, which included Chubb, and at the time he was involved in 2 pending references as Chubb's arbitrator. He disclosed all those facts. The judge nonetheless appointed that arbitrator as the chairperson. He was an extremely experienced and distinguished and well-respected arbitrator, particularly in Bermuda form arbitrations. So far, so good, proper disclosure made and the appointment made against the background of that disclosure. What happened subsequently is that the arbitrator, being a very well-respected and sought-after arbitrator, was subsequently appointed by Chubb as its arbitrator in another arbitration arising out of the Deepwater Horizon oil spill. I'll call that reference 2. And by a different insurer, but represented by the same solicitors in a separate reference, again arising out of the Deepwater Horizon oil spill. Call that reference 3. Again, the arbitrator properly disclosed, prior to accepting those appointments, the fact that he was the chairman in reference 1, and the fact that he'd previously been involved in arbitrations involving Chubb, and the insured did not object to his appointment in references 2 and 3. Again, so far so good. The problem was that the arbitrator didn't disclose to Halliburton, the claimant in the first reference, the fact of his subsequent appointment in references 2 and 3 in related arbitrations. When Halliburton came to learn of those appointments, it raised concerns about the arbitrator's impartiality. It asked the arbitrator for confirmation that he had been so appointed and an explanation of why he hadn't disclosed those appointments to Halliburton in accordance with the guidelines in the IBA guidelines on conflicts of interest. The arbitrator responded saying that he hadn't disclosed the appointments because it hadn't occurred to him that he needed to do so. With the benefit of hindsight, he accepted it would have been prudent to do so, and he apologised. But he explained that there was no real overlap between the issues in references 1 and references 2 and 3, and that he was not privy to any information that was not known to Halliburton. Halliburton maintained its concerns about impartiality and requested the arbitrator's resignation. The arbitrator repeated his view that he hadn't breached the IBA guidelines, but recognising that it was fundamentally important that both parties had confidence in his impartiality, he offered to resign if Chubb consented to him doing so. Chubb refused to consent. Whether that's David Scory's fault or not, we won't ever know. In those circumstances, Halliburton brought a challenge under Section 24 of the Arbitration Act, which provides that a party to arbitral proceedings may apply to the court to remove an arbitrator on the ground that the circumstances exist that give rise to justifiable doubts as to his impartiality. The circumstances relied upon by Halliburton included the arbitrator's acceptance of the appointments by the same instructing solicitors in references 2 and 3, his failure to notify Halliburton of those appointments or give Halliburton the opportunity to object, and his offer to resign but Chubb's refusal to permit him to do so. Now, the challenge was unsuccessful at all levels for different reasons. And the significance of the decision is not in the outcome, but rather in the detailed consideration given by the Supreme Court to the duty of impartiality and fairness upon an arbitrator, and the resulting duty upon an arbitrator to disclose facts which might give rise to justifiable doubts about his or her impartiality. And there is a comprehensive articulation of the relevant principles, providing guidance in an area which had not been clear or very clear before then. The Supreme Court received submissions not only from the parties, but no doubt because they decided they required further guidance in light of the fact that David Scory was acting for one of the parties. They also received submissions from the ICC, the LCIA, the LMAA, GAFTA and CIARB, and GAFTA's submissions in fact made reference to the rules and practices of ARIAS. So the Supreme Court's decision and analysis was informed by and reflected an extensive consideration of arbitral practices and rules in different fora. The first and critical point decided by the Supreme Court is that there is a legal duty upon arbitrators to disclose matters which could give rise to doubts as to their impartiality. It was not just good practice to do so, it was a legal duty. That duty derives from the duty which is upon all arbitrators in English-seated arbitrations under Section 33 of the Arbitration Act to act fairly and impartially. And in some cases, it also is a duty that arrives under particular arbitral rules. The Supreme Court rejected the submission that there was a distinction to be drawn between party-appointed arbitrators and chairpersons, and between party-appointed arbitrators and arbitrators appointed by the court or arbitral institutions. It held the duty to act impartially and fairly applied equally to all arbitrators, and therefore there was the same duty to disclose circumstances which could give rise to doubts about their impartiality. The scope of the duty is to disclose facts and matters in circumstances where the fair-minded and informed observer, having considered those facts and matters, would or might reasonably conclude that there was a real possibility that the tribunal was biased. Now, there's a fairly extensive discussion in the Supreme Court as to what is meant by a fair-minded and informed observer. One might have thought that was a fairly self-evident concept, but one point which bears emphasis is that the Supreme Court accepted that that meant that the observer was informed about the relevant arbitral practices, customs, and context. And that can be quite an important point. The Supreme Court decided that it was not necessary that the matters must be ones which the fair-minded observer would conclude gave rise to a real possibility of bias. It was enough that they might reasonably conclude that there was a real possibility of bias. And importantly, the Supreme Court also held that depending on the facts, the failure to disclose the circumstances could itself be a factor which gave rise to justifiable doubts about the arbitrator's impartiality, although it would not do so in all cases, and as we'll see, it did not do so in this particular case. A further important point which the Supreme Court made clear and which has important implications in practice is that the duty to disclose does not override the arbitrator's duty of privacy and confidentiality as regards arbitrations in English law. Generally speaking, all arbitration with English sheets will be private and confidential, and the arbitrator will have a duty to respect that privacy and confidentiality. Now, that potentially could, of course, give rise to real difficulties, because the confidentiality of one arbitration might prevent an arbitrator from giving the requisite disclosure in another arbitration. Suppose that the arbitrator in Halliburton had recognised that he did have a duty to disclose the fact of his appointment in reference free to Halliburton. The parties to reference 3 were entirely different parties. Suppose they had refused to consent to him disclosing anything about that reference to the parties in Halliburton. That would put him in a position where his duty to disclose conflicted with his duty to respect the privacy and confidentiality of the third reference. And the Supreme Court, as I say, is clear that the duty to disclose does not override that duty of privacy and confidentiality. However, the Supreme Court ameliorated those problems to a large extent by making clear that disclosure of certain information may be made without obtaining the express consent of the parties to the relevant arbitration, where the necessary consent to disclosure could be inferred. And it further held that such consent could be inferred, in some circumstances, from the arbitration agreement itself in the context of the custom and practice in the relevant field. So, in particular, where the arbitral rules of under which a particular arbitration is being conducted themselves require disclosure about potential conflicts of interest, such as, and we'll look at them, the ICC or LCIA rules, then the parties are taken to have consented to the arbitrator disclosing certain information about the arbitration in connection with his or her potential appointment in relation to a different arbitration. So the takeaway, and we'll come on to think about the practicalities of that in some detail in a little while, is that you need to be conscious when giving disclosure of your duties of confidentiality in relation to other arbitrations. A further key point made by the Supreme Court is that the duty of disclosure is a continuing one. And that, of course, was what gave rise to the problem at Halliburton itself. The arbitrator had made proper and full disclosure upon appointment. The difficulty arose from the fact of subsequent appointments. And for very busy and successful arbitrators, as this arbitrator was, there might be numerous subsequent appointments which require disclosure. And that's another practical problem that I'll come on to discuss how certain arbitrators have developed ways of dealing with that. The particular case or circumstances which were under consideration in Halliburton were the facts that the arbitrator had been appointed in multiple references concerning the same or an overlapping subject matter where only one of the parties was a common party. And of course, in insurance and reinsurance, those circumstances might arise very frequently, do arise very frequently in towers on Bermuda forms or other excess insurance. The question was whether that fact of appointment in multiple references with overlapping subject matter was something which might reasonably cause the objective observer to conclude that there was a real possibility of bias, or put a different way, might give rise to justifiable doubts about the arbitrator's impartiality. What the Supreme Court held, having heard, as I say, quite extensive submissions from different arbitral institutions, is that this was context specific. Where an arbitrator accepts appointments in multiple references with only one common party concerning the same or overlapping subject matter, that might, depending on the relevant custom and practice, reasonably cause the objective observer to conclude that there is a real possibility of bias. Now, the Supreme Court received representations from GAFTA and LMAA to the effect that there was an established custom in GAFTA and LMAA arbitrations of arbitrators taking on multiple appointments in references with overlapping subject matters without disclosure, and that the parties to those arbitrations did not expect such disclosure, and that this was established practice. And the Supreme Court accepted that in those arbitral fora, the fact that an arbitrator accepted appointments in multiple references with only one common party was not, therefore, something which would reasonably cause the objective observer to conclude that there was a real possibility of bias. It was established custom and everyone knew that it happened. There was therefore no duty upon the arbitrator to disclose appointments in those arbitral forum. However, the Supreme Court was not persuaded that there was such established practice in Bermuda form arbitrations, and it therefore concluded that in the context of the Bermuda form arbitration, there was a duty upon the arbitrator to disclose the fact of an appointment in another related arbitration in a similar subject matter involving only one common party. So the Supreme Court held that the arbitrator ought to have disclosed his appointments in references 2 and 3 to Halliburton in reference 1. Notwithstanding that, the challenge under Section 24 of the Arbitration Act 1996 was unsuccessful. The arbitrator had explained that the reason that he had not disclosed the the appointments in references 2 and 3 to Halliburton was oversight. It hadn't occurred to him that he was under any obligation to do so. The Supreme Court felt that in those circumstances, looking at the facts as known to the court at the date of the hearing, and that's one important point, the timing is the court makes its assessment at the date of the hearing, the fair-minded and informed observer would not infer from the oversight of failing to disclose that there was a real possibility of bias on the arbitrator's part. So ultimately, the challenge was unsuccessful, no doubt due to David Scory's unbelievable advocacy, but there was an extensive and informative discussion of the duties of disclosure. So that's what was decided in Halliburton. Where does that leave arbitrators now as to what disclosure should be made, when and how? The first point to note is that it depends upon the arbitral context. And there are different practices and different rules, and so in each case it's necessary to consider the particular arbitral fora in which the question is being raised. Some arbitral institutions have explicit rules and very detailed rules about what must be disclosed and when, and arbitrators must therefore comply with these rules, as must parties. And as I've already noted, the Supreme Court received representations from the ICC, the LTIA, LMAA, and GAFTA. And what emerged from those representations was that there are very different practices in the different forum. The ICC, the rules are generally regarded as the most stringent, and a colleague of mine noted that they had recently filled out a very extensive form provided by the ICC, asking very extensive questions about their practice and about very remote connections with instructing solicitors and affiliates of parties, and spent quite a long time filling out that form, only to be told subsequently by the ICC that it never makes appointments when there's even the remotest connection to the parties. So you might want to bear that in mind before you start going through the due diligence processes required by the ICC. The LCIA rules, again, can be quite stringent. By contrast, as the Supreme Court noted, in LMAA and GAFTA, it's commonplace for there to be multiple appointments and of the same arbitrator in related subject matters. I asked David Scory as I walked in exactly what the rules were in ARIAS, and he had no idea. And the short answer is whatever they say, they've been superseded by Halliburton, and that the approach that everyone should, as a matter of good practice in order to protect themselves, now take is the one that I'm going to come on to discuss. And that is to follow the IBA guidelines on conflicts of interest. I spoke to a number of arbitrators, as I said, some very experienced and very distinguished. Only those, I think, who had the most confidence felt that they were content to proceed with accepting appointments without giving disclosure post-Halliburton. Some who only accept GAFTA or LMAA appointments take the view that given the clear carve-out from the Supreme Court, they do not need to disclose anything when accepting appointments in those arbitrations. They will have asked, but they won't volunteer. Most people with whom I spoke, where they have a variety of appointments in LMAA and GAFTA appointments, but also in other arbitrations, take the view that the only safe course is to follow the IBA guidelines in all cases, unless the arbitral rules themselves impose something more stringent, in which case they will comply with the arbitral rules. Those guidelines, which I'm going to come on to discuss in quite a lot more detail, don't have the force of law, but they have been referred to in numerous contexts, including by the Supreme Court, as representing good arbitral practice. There is no doubt they are a very sensible resource to consult when deciding whether or not disclosure should be given. Some of the arbitrators I spoke to noted that they're very stringent and that they can require very extensive disclosures, but no one doubted that it was prudent to follow them. So coming on to look at the IBA guidelines, they were revised in May 2024, so they are quite up to date. They contain essentially two aspects. One is general standards regarding independence, impartiality, and disclosure, and one is practical application. And there's a hierarchy provided by the guidelines, which is that the general standards prevail. But in reality, I think most people get the most help from the practical application, because what they, in effect, provide is a checklist that one can follow in deciding whether or not it's necessary to disclose something. The guidelines provide that the arbitrator shall decline an appointment or refuse to continue with an appointment if the arbitrator has any doubt as to the arbitrator's ability to be impartial or independent. And I think it's worth reminding ourselves that it's not always just a question of disclosure. We need ourselves to consider whether there are circumstances which give us reason to doubt our ability to be impartial or independent. When, on the very few occasions, counsel appearing before me is someone that I am currently being led by or have recently been led by, particularly on a long-running case, I think that would give me pause for thought about my ability to be impartial and independent. And that duty upon the arbitrator to make his or her own assessment is something which I think we sometimes overlook, and we think that it's sufficient just to give disclosure. But there is a specific obligation not to accept an appointment or to cease acting if there are circumstances which cause the arbitrator to doubt their own independence. The general standards in the guidelines go on to say that the same principle applies, that an arbitrator should decline an appointment or refuse to continue with an appointment if facts or circumstances exist which, from the point of view of a reasonable third party having knowledge of the relevant facts and circumstances, would give rise to justifiable doubts about the arbitrator's impartiality, unless the parties have accepted the arbitrator. And that's where disclosure comes in. It's a similar test to that we've just seen laid out by the Supreme Court. It's worded slightly differently, but the nuances in the language are unlikely to make a difference in practice as to the sorts of matters that should be disclosed. The guidelines say that doubts are justifiable if a reasonable person, having knowledge of the relevant facts, would reach the conclusion that there is a likelihood that the arbitrator may be influenced by factors other than the merits of the case. The guidelines include specific rules about when the arbitrator should disclose facts and circumstances. If the facts and circumstances exist prior to accepting the appointment, they should be disclosed prior to accepting the appointment. But if the circumstances only arise after the appointment has been accepted, they should be disclosed as soon as the arbitrator learns of those disclosures. So, as I've said, and as the Supreme Court held, there is undoubtedly a continuing duty of disclosure upon arbitrators. Now, the general standards in the IBA guidelines specifically provide that advanced disclosure of future circumstances which may arise in relation to possible conflicts of interest does not discharge the ongoing duty of disclosure. And I'll come to that in practical terms, because from the arbitrators I've spoken to, quite a few do adopt a practice of saying at the outset that they will be continuing to accept appointments in accordance with their usual practice. But the IBA guidelines do say explicitly that that is not.
Alarm system is about to be tested. May I have your attention, please? May I have your attention, please? Fire has been reported in the building. This report is being investigated. Please remain at your workplace whilst the fire alert exists. The fire alarm test is now completed.
Do you want me to stop at 10:30? I'll be a bit earlier. So we're just talking about advanced disclosure and the fact that quite a lot of arbitrators take the practice of saying that they will be accepting instructions. But as I say, it does seem to me that the IBA guidelines suggest that is a dangerous approach to take. The guidelines also say that, erring on the side of caution, any doubt should be resolved in favour of disclosure. Again, similar to the approach outlined by the Supreme Court, the general standards expressly provide that if the arbitrator should make disclosure but cannot, as a result of obligations of privacy and confidentiality in relation to the other arbitrations, the arbitrator should not accept the appointment or should resign. Now, in real terms, as we just saw from the Supreme Court, that the sort of stark choice that gives an arbitrator there in prima facie is ameliorated by some extent by the fact that if the arbitration is one which is itself being conducted under rules which require disclosure, then there will be consent inferred to certain information being provided about the arbitration in the context of another arbitration. We've talked about how the duty is a continuing duty, and what the guidelines make very clear is that the stage that the arbitration has reached must not influence the arbitrator's decision as to whether or not he or she has to disclose or whether or not he or she must resign. The only relevant matters that must be considered by the arbitrator in making that decision are the circumstances themselves. What that means is that if an arbitrator, having failed by reason of oversight to make appropriate disclosures at the outset of an arbitration, realizes subsequently that they ought to have made disclosures, or circumstances arise which now require disclosure, they mustn't let the fact that the arbitration has now reached an advanced stage and that the parties have invested time and money influence their decision as to whether they make the disclosure or they decline to act. It might be very inconvenient, and it might result in huge wasted costs if a challenge is brought to them now and the arbitrator were to be removed. But what an arbitrator cannot do is weigh such implications into his or her decision as to whether or not to disclose or to resign. An arbitrator has to give the parties the opportunity to decide for themselves whether they wish to continue with the arbitrator, notwithstanding those circumstances. And what that all gravitates strongly in favour of is making sure you get disclosure at the outset right, so that you're not in a position subsequently of having to make disclosure in circumstances where it could give rise to real inconvenience and wasted costs. We'll come on to see that what the IBA guidelines have is a traffic light system, which provides that some circumstances are such that they give rise to such serious doubts about an arbitrator's impartiality that they cannot be waived. Others, once disclosed, can either be expressly accepted by the parties and expressly waived, or a deemed waiver occurs. And the guidelines provide a time frame for deemed waiver, which is quite short, that if an objection is not raised by a party within 30 days of learning of the relevant facts and circumstances, then the parties are deemed to have waived any potential conflict of interest, and it can't be raised subsequently. Save, as I say, for some circumstances, and we'll see these in more detail, what's called the waivable red list, where the parties have to expressly accept that there isn't a conflict of interest, and the deemed waiver provisions don't operate in those contexts. But in other cases, there is a need on the part of the other party to whom disclosure has been given to raise your objection promptly, or the potential conflict of interest will deem to have been waived. Like the Supreme Court's decision in Halliburton, the guidelines make clear that they apply equally to party-appointed arbitrators and those appointed by the court or an institution, and that there's no distinction in that regard. The guidelines also make clear that a party has an obligation to make disclosure, not just an arbitrator. A party must make disclosure of any relationship between the arbitrator and the parties and affiliated and affected parties. The parties must also inform the arbitrator of all counsel instructed and upon change of counsel. Now, that's something which, in my experience, quite often gives rise to difficulties because parties do forget, if they change or add counsel to their team, to advise the arbitrators of that. I've had a couple of occasions where I've been brought into an arbitration at a late stage. I've done quite a lot of reading in preparatory work. I only find out at a subsequent stage that members of my chambers are arbitrators. Now, I don't regard that as a problem, but the fact that new counsel have been instructed is something which ought to have been disclosed by the parties to the arbitrator so that the arbitrator could raise the point. And I think, looking at Paul Stanley, who's just come into the room, that is something that happened in a case that he and I were involved in. That is therefore something to bear in mind as a party and as an arbitrator, to ensure that change of counsel are advised promptly so that everyone consider the implications of that. An arbitrator can only disclose facts or circumstances that they know, but both the Supreme Court and the IBA guidelines make clear that the arbitrators have a duty to make reasonable inquiries to identify potential conflicts of interest. And failure to disclose is not an excuse if the arbitrator does not perform such reasonable searches. And that gives rise to some practical difficulties, and I'll come on to discuss some practical solutions that various arbitrators have adopted to make sure that they do comply with that obligation to carry out a reasonable search, make reasonable inquiries. So the IBA guidelines contain a helpful articulation of the principles and the general standards. But as I said earlier, for many, where the real value of the IBA guidelines lies is not in that articulation of general principles, but rather in the identification of specific examples of circumstances which do and don't give rise to justifiable doubts about impartiality. And they do this via a traffic light system, with circumstances categorized as red, orange, or green circumstances. And most arbitrators I spoke to, including some very experienced ones, said that in general they now follow this traffic light system. It's not perfect. I had to consult it myself recently, and I have to say that some aspects of it I found quite difficult to understand what it was saying. But as a general approach, if you follow this traffic light system and you consult it every time you're appointed as an arbitrator, you are unlikely to expose yourself to unnecessary challenges. The red list are circumstances where a conflict of interest is understood to exist. And the red list is divided into non-waivable circumstances and waivable circumstances. It's a non-exhaustive list, but the non-waivable circumstances are ones where effectively there's an identity of interest to some greater or lesser degree between the arbitrator and one of the parties. And in those circumstances, the circumstances cannot be waived, and they reflect the principle that no person can be their own judge. So disclosure of those circumstances and acceptance by the parties of the arbitrator does not cure the conflict, and the arbitrator's appointment will therefore remain open to challenge. In the waivable circumstances on the red list, they are still serious circumstances where there's a potential conflict of interest, but the parties can, if they are fully aware of the circumstances, expressly state their willingness to accept the person as an arbitrator. So the deeming provisions, which I talked about earlier, don't operate there. There must be an express acceptance. It is only where the parties have expressly agreed that the arbitrator can legitimately act. The examples, and as I say, this again is non-exhaustive, but some of the examples given in the red list are things like where the arbitrator has previously given legal advice on the dispute or had a prior involvement of some sort in the dispute, where the arbitrator holds shares in one of the parties, if it's a privately held entity, where an arbitrator, and this is possibly the most relevant one, is a lawyer in the same law firm as counsel to one of the parties. There's a detailed list, the non-waivable red list, and best practice is simply to go through line by line, working out whether any of those applies, and if so, make the disclosure of them. Another one which is important and maybe particularly relevant to people is that the arbitrator's law firm has a significant commercial relationship with one of the parties. Now that obviously could happen a lot in the context of insurance and reinsurance arbitrations. Sorry, I should have gone to that slide earlier. So that's just a summary of the red list, and it's worth consulting, as I say, line by line and seeing whether any of the circumstances fall on the red list. And I can say that an experienced arbitrator said that he was very surprised when he read the red list to realise what things were non-waivable, but in particular what things, although waivable, were on the red list and were regarded as giving rise to a conflict of interest. The orange list, again, is non-exhaustive, but it's a list of situations which may give rise to doubts about an arbitrator's impartiality or independence, and therefore there's a duty to disclose them, but the waiving provisions apply. So if there is no timely objection, the parties are deemed to have waived the potential conflict of interest, and the arbitrator can legitimately act. It's stressed in the guidelines that the list of situations is non-exhaustive. And that's important because many of the circumstances are defined by reference to time periods. For example, one circumstance is if the arbitrator has, within the past 3 years, served as counsel for or against one of the parties in an unrelated matter, or if the arbitrator has acted within the past 3 years as an expert for one of the parties. There are similar situations which all have a time frame of 3 years. But what the guidelines clearly state is that in respect of situations falling outside the timelines, there is no presumption that disclosure should not be made. So if I had acted for Chubb on 100 occasions in the last 10 years, but not coincidentally in the past 3 years, that doesn't mean it's necessarily something that shouldn't be disclosed. I need to consider on a case-by-case basis whether that is still something which ought to be disclosed. As I say here, the guidelines make very clear that erring on the side of caution and disclosing if in doubt is the better course. And in the example that I just gave, where I regularly act for Chubb, but I haven't in the last 3 years, it seems to me clear that that's somewhere where I should err on the side of caution and I should disclose. What the guidelines also helpfully have is a green list. And that is a list of specific circumstances where there's no appearance and no actual conflict, and therefore no duty to disclose. And again, that's a helpful list to run through to help you consider whether there are any particular circumstances which, although there's some form of connection, nonetheless simply don't meet the standard for disclosure. One of them, for example, is that the arbitrator has a relationship either with another arbitrator or with counsel for one of the parties through membership in the same professional association. So if I were asked, could I accept an appointment where Paul Stanley or David Scory was a co-arbitrator, the fact that we're all members of COMBAR is not something that I would need to disclose, but the fact that I have been against David Scory or Paul Stanley within the last 3 years, or they've been co-arbitrators, might well be something that I would need to disclose. The practical tips, therefore, as to how to do this in practice are always to consult the IBA guidelines and simply run through them as a checklist to see whether or not any of those circumstances exist. Err on the side of caution, so disclose if there is any doubt about the relevance of the circumstances. The trickiest aspect for most people is not the initial disclosure, but subsequent appointments. That's what gave rise to the problem in Halliburton. For those of us who can count our arbitral appointments past and present on one hand, this doesn't give rise to any real difficulties. But there are, of course, some extremely busy full-time arbitrators who have innumerable appointments. There are some who receive very many appointments to preserve time limits. And although they have no substantive involvement in the arbitration, they have nonetheless been appointed. And what those arbitrators need and have is robust systems for ensuring that all appointments, all parties, all instructing solicitors, all affiliated entities related to the parties are adequately recorded in a way that means upon each potential appointment, a proper but efficient search can be done to ensure that any relevant previous appointments are identified. Now, as I said, the orange list predominantly looks at events within the last 3 years, but it makes clear that those time limits are not absolute. And therefore, this is, I think, something which arbitrators need to do indefinitely to keep a running list of everything that they're appointed in. I talked earlier about advanced disclosure and the fact that many arbitrators adopt a practice of saying, I can accept this appointment, here are the disclosures that I need to make about appointments I've had to date, but in accordance with my practice as a practicing barrister and arbitrator, I will be accepting instructions in the ordinary course. As I said, the IBA guidelines suggest that is not effective, and therefore the better course would be to do that and then continue to disclose. Many arbitrators suggested that although this all sounds extremely laborious and irritating, it can actually be a helpful tool to enable the arbitrators to monitor their own independence and their own ability to act impartially. If your records show that you've been appointed by Kennedy's in 10 arbitrations in the last 5 years, and that you've found in favour of Kennedy's client on every such occasion, and in fact you're acting for Kennedy's in a large case as counsel from which you're deriving 50% of your fee income, that ought to give you pause to just question and satisfy yourself that you are able to act impartially and independently. If I accept an appointment where I'm an arbitrator and my pupil supervisor is counsel appearing before me, and that counsel is therefore someone who's had enormous influence over my practice, my professional career, and who I regard in very high esteem, again, I ought to think carefully about whether that does actually affect my ability to act impartially and independently. So although quite a lot of people, I think, perhaps David Scory included, regard this as a laborious process, it is something which ought, if done properly, to make us question and just satisfy ourselves that we are in fact impartial and independent. The final thing I want to say is that it is important to make the requisite disclosures, but it is also important to avoid inadvertently providing unnecessary ammunition to your opponents. There will always be parties who will take advantage of any circumstances to try and suggest that someone lacks the necessary independence and impartiality. And one particular instance, which was raised by several people who had sat as arbitrators, as something which they are much more careful about than they had been hitherto, is inadvertent and quite often flippant comments that go onto the transcript, which can, on the cold light of day subsequently, appear to give rise to an appearance of bias. Number of people cited to me comments that they had made on a Friday afternoon after a long and difficult hearing, where they had said things like they were internally indebted to counsel for one particular party because of the brevity of their submissions or the fact that they didn't want a right to reply. Now, tone doesn't come across on the transcript. Saying that you're internally indebted to counsel for a party can be something which is then going to be used against you. Of course, arbitration is intended to be more relaxed and informal in many ways than court, but it's very important to be aware that, as I say, flippant and inadvertent comments can be misconstrued and can be used effectively as ammunition against an arbitrator. So I think the takeaway from that is never make jokes as an arbitrator, which is also a good rule for a speaker, I think. I think that was all I was intending to say, and then throw the floor open or ask David whether he's got any questions.
Well, let's start with the floor. Are there any questions for Joe on the practice that's to be employed? If so, I have a roving mic here. I could ask somebody to give that out. If you just give your name, if you wouldn't mind, for the question.
Yeah. Good morning, Joe. My name's Trevor Clegg. I act as an expert witness and an arbitrator, both here in England and Wales, litigation and arbitration, and in the US. I have, in the past, been instructed in something like 150 expert cases and a large number of arbitrations as well. Many of those expert appointments or arbitrator appointments include London market business where there's a subscription slip or multiple subscription slips. So it's impossible for me to keep a track of every single subscriber for every single case that I'm involved in. So my general disclosure is that I have in the past acted for Lloyd's syndicates on multiple occasions. I don't have a record of every syndicate for every instruction, but I make this disclosure. I've never had any pushback from that, but do you think that's an adequate disclosure?
My view is yes, because what you're doing is you're giving sufficient information for the party on the side to assess whether they want more information or whether they're content with what they've got. I think the answer is probably proved by the fact you haven't had any pushback, that people in this industry appreciate that that is very likely to be the case, that subscription markets mean that you won't know every party you've ever acted on behalf of or against, and probably that the following market aren't terribly interested. So that's my own view. David, do you disagree with that?
No, because you're there giving notice that there is something there if they want to investigate. It may be that you can't actually give any more information if they were to ask you for more, in which case they've got to make an election.
Yeah, that is the case. I wouldn't be able to give that information.
But at least they're on notice. It's up to them. And from what you said, the reaction is, well, one would expect that.
What I do tend to do is keep a note of the lead underwriter. So if there was pushback and I had to go back into my records and see who the lead underwriter was, I can do that for some way back, not all the way back, but for some way. And therefore the time element, I guess, comes in. So if it was 15 years ago, I assume there's no presumption of bias from something that happened 15 years ago.
Well, yeah, I mean, so I think both of us feel that it's inadequate disclosure. The key point, as David said, is to provide sufficient information that puts the other party on notice so they can consider whether that is something they want to ask more about or whether they're content, as you would hope they would be, that isn't something which gives rise to any potential doubts about your impartiality.
I did have one situation once where I was challenged on the basis not of actual bias but apparent bias, because I had received a number of appointments from the same party, and that actually led to a hearing and a judgment, believe it or not, which was found in my favour, I'm pleased to say. But that was an expensive process for me. And that was a party, a foreign reinsurer who was, I think, determined to cause mischief.
And there will always be some people who are determined to cause mischief. But I think the point of disclosure at an early stage is to reduce the prospect of challenge later down the line, and the sort of implications of that mischief making at an early stage. I mean, the downside of disclosure, obviously, is that parties who want to be difficult can be difficult and say they refuse to accept your appointment. But in a way, better to have that than the challenge down the line that embroils you in an expensive and difficult process.
Yeah, I did actually offer to withdraw, and my instructing party insisted that I didn't, which is why we ended up in the High Court.
Yeah.
Thank you.
Thank you. Mo, you had a question.
Tina, I'm concerned as somebody that pays for litigation for Swiss Re, you're getting to the stage where you're just about to come to a hearing and an arbitrator finds out that they know a member of the barristers team. That's not anything to do with me as a party there. So I'm just wondering if it's a tactic that an opposing party may use and how that's dealt with if you find out that you then know a barrister.
Most
who then withdraws? Does the new barrister withdraw, or?
Yeah, and most arbitral rules require the legal representatives to advise the panel of their counsel at the outset and of any change in counsel promptly upon intending to make a change. So the arbitrators ought to be advised well in advance of the identity of counsel appearing before them. And the instructing solicitors, that ought to be, and in my experience it is, done as a matter of practice at the outset. Where it's given rise to problems in my experience is where arbitrations become busy and difficult and you need extra hands on deck and people are brought in to do a lot of work and they're not perhaps advised of the identity of the arbitral panel until a bit late. But I think that the situation you've just described shouldn't arise ever because the solicitors ought to have informed the panel at the outset. David, have you had any experience of?
One goes back to the early noughties. People did sort of play games whereby they would bring in a silk and not tell the other side until the day of the hearing. And there is a story of a silk in chambers who went over to Paris for an ICC and did his ta-da moment, here I am, to which the arbitrator said, who are you? What are you doing here? I know you. Nobody's told us you're here. And he was shown the door. Now, you can imagine if you're the paying party, you've just paid handsomely for somebody who's promising you the earth in terms of their advocacy, and they've got to wait outside with a photocopier. Now, now people are much more alive to the issue, and if one's going down the ICC route, particularly if you've got civilian arbitrators, there will be a procedural order with immense level of detail as what needs to be disclosed, and one just has to do it. But as Joe says, one does see it alarmingly frequently where one just forgets. And one then relies upon it. It's normally the Swiss arbitrator to say, I've just noticed on the further and better particulars, as the name of a new counsel, I've checked and there is no conflict. And you go, oh, thank you. So people still do forget about it. If there's an entirely Anglophile, common law English approach, I think it's less of a concern, but best just to avoid the problem and keep an eye on it. The question on the front and then Steve at the back.
Hi, Clarissa Coleman, DAC Beechcraft. I just wanted to make the point that there are cultural views about particularly the Orange List. And I've had Middle Eastern clients or listed Middle Eastern clients who are much more sensitive to barristers in the same chambers or partners in an international firm, albeit in different offices, and just say they cannot accept those kind of situations because their shareholders and certainly the public in their environment would think that that would be biased. So we just need to take care to look at things from the point of view of the parties when we're proposing a change.
Well, I think you're absolutely right. There are cultural differences between. Really, I think the American market is also more concerned about people being within the same chambers or the same law firm than perhaps the English market generally is. But I actually think it's very important to bear that in mind at all times for ourselves as well. We've traditionally at the bar thought there's absolutely no problem with my being independent as regards another member of my chambers. I'm completely impartial. We're self-employed individuals, etc., etc. But as I gave the example earlier of being in front of one's own pupil supervisor or vice versa, having to decide against your previous pupils, it's actually, you need to think, can I really do this? Am I really, David, I'm sure, and Paul will say, of course you can, but But I think it is something you need to consider carefully on a case-by-case basis. And so I think actually the fact that certain clients are more sensitive about it should cause us to stop and think, is this okay or not?
I quite agree. And the idea that, as happened in the late 1990s, you had Ricks and Lake Airways simply saying, look, it doesn't matter about what these foreigners think. This is the way we do it here in England. That's just not acceptable. And the fact that we do it here this way doesn't mean it will be appreciated elsewhere. However, the problem faced with the London seated arbitration, where people want to appoint one of the usual suspects, is that one can count on the fingers of a mutilated hand the number of people who are available who can do a certain arbitration. And they're going to be from one of a handful of sets, and there will be those links. And then it's a matter of trying to juggle that client perception with, well, if it's not one of these three, we ain't got nobody. And that's also a problem. So I quite agree with you. But sometimes one has to have a quiet word with a client to say, well, it's this or nobody. Yeah. Steve at the back.
Thanks. Steve Robson, Gallagher's. And my problem is similar to Trevor's. I've acted as, before I joined Gallagher's, I've acted as an arbitrator in the UK and the US and expert witness in both territories as well. The issue is, I then decided to join the dark side and became a broker. And I've been there 4.5 years, but I'm Global Chief Claims Officer of the group. And therefore, every client, every reinsurer, everybody I've acted with, for, against, whatever, on that process. So Chubb are a massive client, and they're also a massive reinsurer, for example. So with my duty to disclose, because obviously I'm coming to the end of my tenure again, is my CV enough just to say, this is my role, this is what I do? Because I cannot, obviously, you know, third biggest broking house in the world, everybody's a client, everybody's a reinsurer, I've had involvement with at some point. Okay, if we're named as a party in an action, for example, or an E&O issue or whatever, then that would be slightly different. But is it enough just to say, yeah, that's what my role is? Because I just cannot disclose every involvement with every client on every matter, like COVID, Russia, Ukraine, Baltimore Bridge, etc., etc., etc.
Well, I think so. I mean, first of all, I suppose it depends on the level of detail in your CV, and ensuring that what your CV does is explain in sufficient detail what sort of involvement you've had previously with the sorts of parties you're talking about, and so enough that it puts people on notice that they can ask further questions if they want to, and keeping such, I mean, I do appreciate you as a broker acting for numerous people, but just ensuring that there's enough information there. What I do think is still worth doing is running through, as I say, the IBA checklist and just seeing how that it helps to sort of focus the mind on what contact and what relationships you have had with people. And it might help you to just ensure that your CV or disclosure given is framed in a way that actually would, even if it doesn't get into the specifics, give enough information to provide the sort of disclosures that are required. David, what are your...
It's a variant on the point that Trevor made earlier, where you know the lead underwriter on the slip but may not know the others. So you're telling the punters, look, I've acted for probably most of the syndicates, so there may well be some overlap. Your situation is, look, I've acted for all the main players. Here's a CV, you should know that. Well, that's not quite the same as saying, I have acted for Chubb. So I think you can't just give the CV and say, assume I've acted for them. You've got to go further and say, I have in fact acted for them.
So testified or done something in a dispute, rather than just acted as my client, I'm obviously going to fight their corner. Right, that's a different thing. Yeah. Yeah, that's
but also, but there's the other point you raised when you gave specific examples is if you are then asked to be on the Baltimore Bridge arbitration in 5 years' time, to say, oh, I've acted for Chubb is one thing. It's a different thing to say, oh, and by the way, I also broke the risk for them. I think that would also need to be disclosed. The more specific detail one can give, I think one has to do it.
That's fair enough.
Yeah, as Joe said at the outset, if in doubt, disclose, although it's a fine line between you don't want to give ammunition, but in your case, I think one could give more. Jonathan's got a question, I'm afraid.
One comment, Jonathan Sack at BCLP, one comment and one question. So the problem for the bar, I suppose, when looked at from outside of the UK is the way the bar has evolved over the last 20 years, the websites, the marketing managers, the clerk's role and the like. So if you were a non-UK based party and you look at the website of David Scory's chambers, for example, you'll see what looks to you no different from a law firm, both in the US and the UK. So that's why the issue has evolved, I think. That was my comment. On the question, so with LMAA and GAFTA, I think you said that the arbitrators are now tending to give voluntary disclosure because pre-Halliburton, it was pretty horrific where, and I don't practice regularly in that area, but you would find that you would ask the other side, how many times has this arbitrator been appointed by your law firm? And in one case, they said 97 times. Now, they didn't see that there was any reason to even disclose that before we asked the question. And having disclosed it, they didn't see that there was any problem with that. That wouldn't happen any longer, would it? Even in those institutional arbitrations.
The people I spoke to who operate both in those fora but also other arbitral forums said they disclose across the board. So they don't take the view that in GAFTA they will no longer disclose. But I think that's a matter of them taking a cautious approach. There are a couple of people who I think exclusively are arbitrators in GAFTA or MAA arbitrations and still take the view that everybody knows that they will be regularly appointed in related arbitrations and that there is no obligation upon them to disclose. And I think they take comfort from the very clear carve-out in the Supreme Court decision in relation to the LMAA and GAFTA.
But that doesn't feel right, particularly when one of the parties to those disputes is a, quotes, outsider, and therefore is it a disadvantage?
Speaking for myself, I can't see the reason why you would take that approach. It may be that what you don't do, because your practice is so extensive, is give details of every single one. But if you said, I have regularly been instructed by the appointing party, or I regularly am appointed by their solicitors, including in related matters, and I'm involved in them at the moment, you would tell the other side enough. So speaking for myself, I think I'm not required to give any disclosure approach, which some people, as I say, I think do still adopt. It is a slightly dangerous one to take.
Sorry, just to labor. So, but in that situation, so the arbitrator discloses 97 appointments, open square brackets, earning £750,000 over the last 5 years or whatever it may be. And yet the arbitrator doesn't feel that they're in any way obliged to find for the appointing party?
It's an important question that I think everybody needs to ask themselves. I can tell you now that there are some very experienced arbitrators who take exactly that view. They take the view that they are independent, impartial people who have very considerable experience, and who, although they have taken 475,000 over the last 3 years, could have taken it from someone else appointing them. It's not like they're desperate for arbitral appointments.
The problem is, though, that judicial arrogance, which enables them to do it, does not assuage the client, the outsider who's looking on.
And they won't answer the subsequent question, how many times have you found in favour of that law firm, for example?
Well, often, to be fair to them, I'm not sure they could answer that, because I'm not sure they can recall, because I'm quite firmly the belief that they've got no idea who appoints them or what the answer is.
Now it's very clear that it's what a third party would consider.
But to be fair, that has always been the case with apparent bias. So it always matters what the third party thinks, not what the individual person with unshakable belief in their own impartiality thinks. Now, I'm conscious that the coffee is going cold, which is very generously provided. So we're going to break in a moment. If we go back in here for 11 o'clock sharp, and those online could turn their cameras back on at 11 o'clock, We'll come back, but in the meantime, can I ask you all to thank Joe very much indeed.